So you file bankruptcy, you get a bankruptcy discharge on a particular debt, and then later a debt collector is collecting on that debt, and they pull your credit report. Does that violate the FCRA, the Fair Credit Reporting Act? Do they have what is known as a, quote, permissible purpose to pull your credit reports, or is that illegal for them to pull? Well, that's what I want us to look at in this Persinger versus Southwest Credit. It's from the 7th Circuit Court of Appeals, December 22nd, 2021. So a very recent case. Now, there's a big part of this case that we're going to skip over. It has to do with what's called standing. In other words, do you have the ability to bring a case in federal court? And for our purpose, that gets really sort of bogged down in details, and you're welcome to read it if you want. I want to look at it more for the Fair Credit Reporting Act to say, does a debt collector have the right to pull our credit reports after a discharge? And in this particular case, the consumer loses. So we want to know, why does the consumer lose in this case? So let's look and see what's going on. So 2017, this consumer's debt was discharged. A few months later, Southwest Credit Systems began collection activities, and they received a credit report called a propensity to pay score. That's a type of credit report. And the consumer says, hey, you received my credit report without a permissible purpose, so you violated the Fair Credit Reporting Act. And this was done really as kind of a class basis. All right, so they say the district court threw the case out and we affirm. So the consumer loses. So why did the consumer lose? Again, some of these facts we're kind of skipping over, and then we'll come down to how does Southwest Credit know whether or not a debt that it's thinking about collecting has been discharged in bankruptcy. So they will order a bankruptcy scrub from LexisNexis. So LexisNexis, which is both a credit bureau itself, but also a vendor. So credit bureaus hire them, debt collectors hire LexisNexis. So there's a lot of misunderstandings out there about LexisNexis, about what it can do, and if you freeze your report or opt out, and we're not getting into that. Just understand LexisNexis provides a service to debt collectors. So they search for bankruptcy information. And if they discover, hey, this account was discharged in bankruptcy, they tell Southwest. Now, if they don't find that, then LexisNexis stores the account and they do continuous searches for bankruptcy. And if they find any, then they tell Southwest, hey, this account was included in bankruptcy, and Southwest will close the account. So January 2018, Southwest received a delinquent account in the consumer's former name, and this is for, it says a Viasat Residential. And this debt, though delinquent since 2014, was not listed in the 2017 bankruptcy petition. So we'll come back to that in a moment. So Southwest ordered bankruptcy scrub. LexisNexis did not return any bankruptcy results. Remember, the account was not listed in the bankruptcy petition. So Southwest proceeded in its collection efforts. So they order what's called a propensity to pay score from a CRA, a credit bureau. It's not a full credit report, but it's a soft pull. And it basically predicts how likely is the consumer to pay. And so you get a scale, 400 to 800, unlike a hard pull. Soft pull is not visible. Third parties does not affect one's score. And the reason that Southwest ordered that is the bankruptcy scrub did not return any data. But then later, LexisNexis found out, hey, this account was discharged in bankruptcy, so Southwest closed it. So the consumer files a class action complaint saying you violated the Fair Credit Reporting Act. So after discovery, that's where we take depositions. We ask them for documents. They ask us for documents. After all that, then you have what are called motions for summary judgment, where both sides were saying, we don't even need a trial. Judge, you can rule in our favor. The district court, that's a trial court and federal court, granted Southwest motion and denied the consumer's motion. And so that threw the case out. And so the consumer appeals and says, hey, summary judgment should not have been granted in favor of Southwest. So they say before proceeding to the merits, we have to answer the jurisdictional question of whether the consumer had standing to sue. Now, we're not going to go through this. If you're interested, there's all sorts of stuff in here. We'll get kind of to the toward the end of it, and we'll talk just a moment about it here. So to sum up, history and precedent just means prior case decisions, compel a simple result. Consumer has standing to sue. She testified Southwest invaded her privacy when it reviewed her credit information, and that is what's known as a concrete injury, because it's similar to the common law tort of intrusion upon seclusion. Another name for that is invasion of privacy. Thus, she had standing to sue. So now they turn to the merits. This is what we're looking at. So sharing credit information, though often necessary in the modern economy, can result in significant invasion of privacy and can jeopardize the consumer's personal, reputational, and financial well-being. Okay, so that's just a fact. To protect against that, the FCRA provides a private right of action for injured consumers. All that means is you have the ability to sue. Sometimes when the law is violated, only the government can sue. But here, if somebody pulls my credit report and they don't have permission to do that, what's called a permissible purpose, then I can sue. So there's two types. There's negligent violations. So you get actual damages. Another name for this is compensatory damages. So this is how you were actually harmed, or this is what it would take to compensate you, to put you back where you were before you were harmed. Then there's a willful. Also, this can be reckless or intentional, all the same thing. Willful violation entitles a consumer to actual damages, again, compensatory damages, or statutory damages, which can be $1,000 per violation, with punitive damages left to the court's discretion. So the consumer says, hey, there was a negligent violation and a willful violation. So let's look at this. So to prove a negligent violation, you have to have actual damages. So this is where a lot of people get confused. They think about the FDCPA. So when we're suing debt collectors, Fair Debt Collection Practices Act. If there's a violation of law, you can get statutory damages. You don't have to have actual damages. Well, under the FCRA, you have to have actual damages because that's all you can get for a negligent violation. So let's look here. Actual damages require a causal relation. In other words, some connection between the violation of the law and the harm that you suffered. So what are some of those types of harms? There's basically two types. And the court here uses the word pecuniary or non-pecuniary. We might use economic. In other words, like this actually cost me money, or non-economic, which would be more of like emotional distress damages. So they say it may inflict pecuniary harm like lost income or out-of-pocket expenses caused by denials of credit, housing, or insurance. So you might lose your job because of something that happens with your credit report. You might get a higher interest rate for a loan. You might not get a house. So there can be actual out-of-pocket expenses. Non-pecuniary or non-economic harms include reputational damage and emotional distress. And these harms must be described in reasonable detail. Conclusory statements are insufficient. Now, different courts have different standards for this. So I would say the Seventh Circuit is probably a little more strict on this than some other courts. But just understand, wherever your suit is, you have to understand what are the requirements to prove what they call reputational damage, or more commonly just called emotional distress or mental anguish. And then they say, however you frame your case, in other words, however you say you've been harmed, you have the burden to prove actual damages, whether that's economic or non-economic. So let's see what happens here. So to survive the motion for summary judgment, trying to throw out her negligence claim, the consumer was required to offer evidence showing that Southwest impermissibly pulled her score, her credit report, causing her pecuniary, economic, or non-pecuniary, non-economic harm. She failed to do so. So let's take first the pecuniary, the economic harm. She disavowed any loss of credit, housing, employment, money, or insurance. And so they say, so you gave that up. Okay, but she did say this caused her stress and anger. But damages for emotional stress must be proved with more than conclusory statements. Okay, now I don't know how much she testified to this. I don't know if the court is accurate or inaccurate with how they're describing it. But here's the bottom line conclusion. Remember, for a negligent violation, you have to show actual damages. She not only failed to support her claim for actual damages, she also disproved it. With respect to negligence, summary judgment was appropriate because no reasonable juror could conclude that pulling her credit report resulted in actual damages. Okay, so is that the end of the story? No, because she also says that this was a willful or intentional violation. So she may still recover statutory or punitive damages by proving the defendant willfully violated the FCRA, Fair Credit Reporting Act. So we did this in a video, I think yesterday, where we talk about what's the standard for a willful, intentional, reckless violation. So let's see what the 7th Circuit says, because we looked in a case under the 11th Circuit, which is Alabama, Georgia, Florida, and this is the 7th Circuit. So a willful violation is one committed with actual knowledge or reckless disregard for the FCRA's requirements. That's the Safeco case, which is a U.S. Supreme Court case. So when does it recklessly violate? When it commits a violation under a reasonable reading of the statute's term and its erroneous reading runs a risk of violating the law substantially greater than the risk associated with the reading that was merely careless. That's kind of a lot of words. Let's see if we can unpack that as we go through here. They say the Safeco standard raises a sequencing issue, and they kind of use some big words here. But again, as we go through this, I think it will make sense. So the FCRA prohibits consumer credit reporting agencies from furnishing a, quote, consumer report except in circumstances that are listed, okay? So, and there has to be a permissible purpose. So let's go to this footnote. Southwest does not dispute a propensity to pay score is a consumer report. So here's the definition of a consumer report. Any written, oral, or other communication of any information by a consumer reporting agency bearing on consumers' credit worthiness. They say, yep, propensity to pay score, that fits that perfectly. So we know this was a credit report. Now, did Southwest have permission to pull that? So a person shall not use or obtain a consumer report unless it is obtained for a permissible purpose. Now, let me just say this. Oftentimes people say the only permissible purpose is when I give permission. That is not always true. Okay. Now, that's generally when we find a permissible purpose. But there can be a permissible purpose even when you, the consumer, do not agree somebody can pull your credit report. So we can't go just on assumptions or what we would like the law to be. We have to say, well, what does the law actually say? So let's look at this. So the consumer claims the debt collector violated Section 1681B and then subparagraph F when it obtained her report. And they say, well, look at 1681B A3A, which allows a person to obtain a report if, number one, intends to use the information, number two, in connection with a credit transaction. Might be a little bit of a problem here, but we're going to kind of skip over that. Number three, involving the consumer on whom the information is to be furnished. And then number four, involving the extension of credit to or review or collection of an account of the consumer. So it needs to be extending credit or reviewing an account or collecting an account. So let's see what we find here. So they point out the consumer, there's a premise to their argument that this section that we just went over does not apply when a consumer's debts have been discharged in bankruptcy. And they say, well, that's a little too broad. And then they kind of chastise both parties. This nuance seems to have eluded the parties here. Okay. Now, there is this footnote 5, whether transaction is a credit transaction is unclear, but they say the consumer waived that argument. All right, so let's go down here. Plain meaning of that section, which the debt collector says this is what gives us our permissible purpose, does not unambiguously forbid access to credit information relating to an account subject to bankruptcy. So they're saying, look, it is not 100% true that if you have an account that's been discharged in bankruptcy, that nobody can ever pull your credit report related to that. I'll say this. Even though the Seventh Circuit says this, I think they would admit it's like 99.99% true, okay? So we'll see how this plays out. So when a debt collection agency intends to use a consumer report in connection with a credit transaction, the agency may obtain and use that report if it also intends to use the report to, number 1, extend credit, or number 2, review her account, or number 3, collect on her account. And they say the consumer focuses on that third option, which is collect the account. And notice what the court says. To the extent the debt collector intended to use the consumer's credit information to collect on the debt, the consumer's right. The debt collector would be unable to claim the statute, okay? Because there's no debt to collect. So you can't have a permissible purpose to collect a debt that you have no right to collect. And it says, because Southwest does not suggest it had a reason for getting the credit report other than for collection, then there's no justification for pulling the credit report. And so they say obtaining a propensity to pay score for the purpose of collecting on discharge debt violates FCRA absent another permissible purpose. Now, there's a concept when we're reading case law. We have the actual decision, and then we have what's called dicta, D-I-C-T-A. And that is just when the court starts talking about stuff that it's not necessary to talk about. And they can be kind of signaling some guidance for the future, but it's not binding on the court. And so from a very strict standpoint, Southwest did not say they were trying to get the credit report. Go back up here, these 3 reasons. They didn't say we were trying to extend credit, because they weren't. They didn't say we were trying to review her account. You know, like we have an account with her and we're trying to review it. Kind of like Capital One might review your credit report every month if you have a Capital One account. They were only trying to collect. So that's all the court needed to say. Now the court goes on to say, well, but don't read this too broadly about a bankruptcy discharge. Now again, they don't need to do this, but they're, whether good or bad, they're trying to give some guidance here in the future. So let's see what they say, because we want to get some insight into the court's mind here. So indeed, Southwest never concedes that it always lacks a permissible purpose when bankruptcy impacts. So one of their officers in testimony admitted to having a policy against proceeding with collection efforts after it learns the debt's discharged. This policy is grounded in practical and legal realities. A discharged debt cannot be collected. It's unlawful to try to collect it. But Southwest's chief compliance officer rejected the idea that bankruptcy made it illegal for Southwest to obtain the score altogether, because it's possible that there might be some reason the FCRA would allow. Okay? They say, now we think that interpretation is correct, as do other courts, by recognizing this statute that we've been looking at, 1681B, is not categorically inapplicable where the underlying debt is discharged, that would be in bankruptcy, or the underlying account is closed. I'll say this. In my view, those are radically different things. Okay? An account being closed, it may be closed and you still owe money on it. It may be closed and it's charged off. It may be closed and you have a payment plan with them. That, to me, is fundamentally different than an account that has been discharged where it is absolutely illegal to try and collect on this. But the Seventh Circuit's kind of merging these. Okay? Then they say, all right, let's summarize. A firm violates the FCRA when it obtains a consumer report without a permissible purpose. Absolutely true statement. One permissible purpose is intending to use the credit report to collect on an account, but that's unavailable when the underlying debt is discharged. Again, all of that is correct. Thus, a collection agency cannot claim this Section 1681B as a permissible purpose if its sole purpose for accessing a consumer report is collection. Other reasons may justify getting that, but here, Southwest intended to collect on it, and so their inquiry fell outside the parameters. Just sort of fancy way of saying they pulled the credit report with no permission, no permissible purpose. They violated the FCRA. Okay, so the Seventh Circuit, after saying all that, they come to the conclusion, hey, debt collector, you violated the law when you pulled this credit report. Okay, now that's half of it. We have a violation of the law, but do we have damages? Okay. Well, they've already decided there are no economic damages and no emotional distress damages. So now the only way the consumer can win is if this was a willful violation. So when Southwest violated the law, was it willful or just negligent? If it's just negligent, the consumer loses because the consumer has no damages, according to the court. So the consumer says, well, there's two things to look at. How they handled the 2017 bankruptcy notice and then the bankruptcy scrub procedure. And the court says, no, instead of those proving an intentional violation, they actually proved that the scrubs were very reasonable. You know, what this debt collector did was actually reasonable, not willful. So willful violation is one committed with actual knowledge or recklessness. So it gets a little detailed in here in some of this, but I think we'll get a sense of what's going on and then we'll get to the conclusion. So they say, we must determine whether the collector's failure to reveal her bankruptcy occurred with actual knowledge or recklessness. So just think, as a matter of fact, the debt was discharged and then Southwest pulled the credit report. Okay, so that's factually true, but we want to know, well, did that violation, was that just careless or was that intentional? And the court comes back to something I said toward the beginning. A critical problem is the consumer failed to list the debt with the bankruptcy petition, which is a document you file in bankruptcy court saying, here's all my debts, and this debt was left off. So the bankruptcy court did not send a notice to any creditor. So here's what, according to the court, the consumer argues. Well, the debt collector should have a procedure for annotating its computer system with bankruptcy information for application to future accounts. Okay, what does that mean? This theory would require Southwest to retain bankruptcy information for consumers that may never have an account placed with Southwest. More specifically, the debtors listed on the discharge order other than the debtor. Okay, so they're saying like you need to build sort of your own database because it's possible you might find somebody. The court goes, no, we're not doing that. This prophylactic measure is not reasonable. All right, so then let's go on. Again, you can read this, yourself. It gets a little sort of complicated about, well, what happened during this Lexis scrub or this LexisNexis scrub. And so here's what the court says. There's no dispute. The only positive bankruptcy scrub, or that only positive bankruptcy scrub results are returned. So in other words, LexisNexis does a search. If they don't find anything, they don't tell Southwest. They only tell Southwest when it's positive. So the consumer says, well, Southwest received notice of her bankruptcy on January 4th, before the credit report was pulled May 22nd. And they say, if true, that would demonstrate actual knowledge and willfulness. So this is important for us. They're saying, look, if Southwest knew that you filed bankruptcy in January, and then sometime after January they pulled a credit report, that is willfulness. Okay? And they sort of argue about some deposition, and here's what the court concludes. This testimony merely reinforces this witness's testimony that only positive bankruptcy scrub results are logged, not negative. So testimony explained that a functional, quote, no from LexisNexis, in other words, not receiving a report, greenlights collection efforts, but this no does not appear on the account notes. This is what happened here. Southwest ordered scrub, received no results, continued to collect. Then when it got the information, it shut down the account. So they say there's no genuine dispute that Southwest first learned of the 2017 bankruptcy in May, when LexisNexis returned bankruptcy information, and they promptly closed the account at that point. And they say, to be sure, the consumer's debt was discharged by the time Southwest obtained her credit report. So there was no permissible purpose, but they lacked actual knowledge of the bankruptcy, and the collector did not recklessly disregard the possibility that debt has been discharged. Had a reasonable basis for its procedure. Now they do have a footnote here. So normally if you don't list an account in bankruptcy, it's not discharged, but most circuits have a rule that if it is what's known as a no asset bankruptcy, which is almost all Chapter 7 bankruptcies for consumers, then basically either it is discharged or you can go back later and have it be considered discharged. So the parties agree the bankruptcy resulted in no asset discharge, and so that's why when we come back up here, lacked actual knowledge and it did not recklessly disregard the possibility debt's been discharged. Okay, and then back up here, to be sure the debt was discharged. It technically wasn't, but they're saying we understand as a practical matter that it was. All right. And then they also say the potential class contains 996 members. So this would be 996 people. Southwest pulled their credit report on a debt that had been discharged. And Southwest maintains accounts for 1.8 to 1.9 million consumers. So they achieved a 99.9% compliance rate. Now, that doesn't mean that none of those other people could sue. What it means is those other people need to be able to show that either they have actual damages or that Southwest knew or should have known that the bankruptcy had happened and they were reckless in not discovering the bankruptcy. So it doesn't mean that Southwest is perfect the way they're doing it. It just means this consumer loses because they did not prove actual damages. It is mission critical, if we're going to claim actual damages, that we be able to prove it, either economic, or what this court calls pecuniary damages, or non-pecuniary, non-economic damages, which is basically emotional distress. And to prove willfulness, we need to show that they have a bad interpretation of the law. That's what we talked about in our last case. Or here that they knew or were reckless in not finding out about the bankruptcy before they pulled the report. So remember, if we go back to this statement right here, Southwest received notice of bankruptcy in January, pulled her report in May. If true, this would demonstrate actual knowledge and by extension willfulness. And then they say, but that actually is not true. So hope you enjoyed this. Let me know what your thoughts are about this, and I will talk to you in our next video. Okay, have a good one. Bye-bye.